Good morning, everyone. Coming to the last module, that is the fourth module in this series of videos on the course, that is the comprehensive guide to the Indian patent system. In this module, we will be discussing about the patent apposition, compulsory licensing, and infringement. These are the three important things which we have to learn regarding the Indian patent system. So, I am covering these three topics in this final module. Coming to the opposition to the patent, as we had seen in the previous videos regarding the patent filing procedure, we had gone through the step that sometimes objections will be coming. Apart from the objections, sometimes there will be oppositions also. Okay, the Indian Patent Office provides a period during which the third parties may oppose the grant of the patent. So the opposition proceedings may be pre-grant or post-grant, but there is certain time limits regarding that. The section 25(1) of Indian Patent Act talks about the pre-grant apposition, whereas 25(2) talks about the post-grant apposition. Moving into the deep, what are the grounds of opposition? In which grounds they can oppose the patent? The third party can oppose the patent. One is wrongfully obtaining the invention, and anticipation by prior publication or by prior date, prior climbing in India, or if there is a prior public knowledge or public use in India, and if they feel that there is a lack of inventive step or non-patentable subject matter as per section 3 and 4 we had seen, which are non-patentable subject matters. In the module 1 we had discussed regarding those, and also there is insufficiency of description of the invention. In all these grounds, the third party can keep the opposition, can file the opposition for the patent. And also this what in this grounds when they have to file. Okay, the pre-grant opposition can be filed before the patent is granted, and patent application not filed within 12 months of filing of the first application in a convention country. In that ground also, that is convention application, as we had seen, within 12 months we have to file. If in that case also, if the patent application is not filed, that also they can keep. And also the wrong mentioning of source of biological material also they can mention as a ground of opposition. And now moving on to the what is the type of pre-grant opposition, what are the rules, and post-grant opposition we shall see. In the pre-grant, no patent shall be granted before the expiry of a period of 6 months from the date of publication of the application. The first thing is the patents should not be granted before the expiry of period of 6 months from the date of publication of the application. In other words, that is the third parties have at least 6 months for the for filing the pre-grant opposition. They have to file the pre-grant opposition in Form 7A. If the controller is of the opinion that the application should not be refused or be amended, he shall notify that effect to the applicant together with a copy of the opponent document. Whereas here I am not covering about all those. Form 14 is used by the applicant to give answer to the opposition. That is a Form 14 he will be using. 7 for a filing opposition and 14 for giving reply to the opposition. Okay, and that is about the pre-grant opposition. In response to the opposition, applicant may file his statement and evidence, what I am saying, that is within 3 months from the date of the above notice. He will be using the Form 14 day. Okay, on consideration of the statement and evidence from both parties, the controller will decide whether a patent should be granted or not. That's about the pre-grant opposition. Coming on to the post-grant opposition. Post-grant opposition, if we observe about the post-grant opposition, once a patent is granted, the third parties have another opportunity here also to file an opposition. Such opposition should be filed within 1 year from the date of the grant of the patent. That is a very important thing which we have to remember. Within a period of 1 year from the date of publication of grant of patent they have to file. And in which form they can file? Here form 7. Form 7A pre-grant, form 7 is post-grant. The controller shall notify the patentee where such notice of opposition was submitted, and here also the same, the patentee will be given opportunity to respond and to submit the evidence within 2 months from the date of receipt of the copy of the opponent's statement and evidence. Here he will be using the form 14 for the reply. And here I have just included a case study, that is a patent application which is entitled sterile pharmaceutical composition. So here you can see that it will be having an anti-cancer agent and a pharmaceutically acceptable carrier, that is albumin. Here if you see the ratio of albumin to the cancer, was 1:1 to 9:1. The applicant claimed that the size of the particle also, and the claims 2 to 12 were dependent claims on the claim 1. In the claims there will be two types, independent claims and dependent claims. Okay, so the opposition here was filed by Natco Pharma Limited, Hyderabad. Actually here it filed a opposition. So what happened means the patent was refused on the ground that that is 3E, 3D, 3E. If you observe, 3D is mere discovery of something and 3E is just a mixture of something. Here if there is no improved therapeutic efficacy and it is just a mixture of something, then they can file the opposition on that grounds. Okay, the specifications were also insufficient, that also had done. So rejection was also on the ground of under section 10 of the patent act. They had rejected that, they had rejected it. Okay, so this is a case, simple case which we can understand regarding how the patent opposition will be filed, on which grounds they can file the patent opposition. And many other cases also, if you want to go through, you can see the Hindustan Lever versus Godrej soaps. Here also the applicant was failed to disclose to the controller the information regarding, and because on basing on this both the parties, the opposition was dismissed. Here the opposition was dismissed and the patent is proceeded. Okay, so here also that both the parties, the grounds of opposition what they had filed is prior publication and prior using of prior public knowledge and non-patentability and insufficiency and clarity of description. Based on these grounds they had filed the opposition, but on hearing both the parties, after considering the notice of opposition statements and evidences from both the parties and hearing, the opposition here is dismissed. And coming on to the stages in the grant of patent, already which we had seen, up to grant we had seen, you can observe pre-grant opposition and post-grant opposition is there, and finally the decision of the controller is the main thing. And then sometimes a decision of the revocation of patent also will be happening. These are the different things which you have to remember. And next, moving on to the next, that is surrender and revocation of patents. A patentee may at any time by giving notice in the prescribed manner to the controller can surrender his patent, whereas the revocation of patents here, that is the central government, if is in opinion that the patent or the mode in which it is excised is mischievous to the state or generally prejudicial to the public, it may, after giving the patent an opportunity to be heard, make a declaration to that effect in the official gazette, and thereupon the patent will be deemed to be revoked. And then moving on to the compulsory licensing. Compulsory licensing is another concept which you have to understand in the patenting. In the cases of national emergency or extreme emergency and in cases of public non-commercial use, this compulsory license will be issued. It is under section 92 it is issued. As per the section 84, any person regardless of whether he is a holder of the license of the patent can make request to the controller to grant the compulsory license on expiry of 3 years. That compulsory licensing request can be done only after expiring of 3 years after the patent is granted. Okay, the reasonable requirements of the public with respect to the patent, in these grounds, on these three grounds they can file, they can ask for compulsory licensing, the request they can do. One is the reasonable requirement of the public with respect to the patent invention have not been satisfied, and the other, the patented invention is not available to the public at reasonably affordable price, and the patent invention is not worked in the territory of India. On these three conditions, they can file the request for the patent compulsory licensing. So that is about the compulsory licensing. Here you can observe India's first compulsory license case, which is a very interesting case, that is between the Bayer and NATCO. This is the first case of compulsory licensing. You can observe here this case, and you can go through this case overview. The Controller of General of India had passed an order of compulsory license against the Bayer's patent drug Nexavar, which is India's first compulsory license. This is described under Section 84 of the Indian Patent Act. Okay. And next, the restoration of lapsed patents. Patents will be lapsed when we are not paying the fee, annual fee. So the restoration of lapsed patents can also be done. The patentee or his legal representative, or where the patent was held by two or more persons jointly, then with the leave of the controller, one or more of them, without joining the others, within 1 year from the date on which the patent is ceased to have effect, make an application for restoration of the patent using Form 50. Okay. And the rights of patents of lapsed patents which have been restored, the same right as given in the original patent, that is the rights to co-owners. Each will be having equal and undivided share in patents, that we have to remember. And next, coming to the last concept in this patent system, that is patent infringement. If any person exercises the exclusive rights of the patent holder without his permission within the country of patent grant and during the patent term, then we will be calling it as patent infringement. A person is liable for infringement if his product or process is the same as the patented invention. Okay, as claims in a patent define boundaries of the invention, a product or process patent will be infringing if it falls within the scope of the claim. We have to remember that the claim, the what all we claim in the patent specification, that claims only will be protected, that is the boundary for protection. So in types of patent infringement, there may be direct infringement and indirect infringement. Direct infringement is a common type, that is this infringement includes marketing, sale or commercial use of the patented item, whereas the indirect means when the infringement has happened, however that is inducted or contributory will be there, that is where one actively induces the other person to infringe a patent by either encouraging or aiding or inducing him to do so, whereas contributory is it is an intentional participation or assistance by one party in an act of infringement in the other party. So these are called as different types. These are the different types of patent infringement. Here you can observe the examples of infringement. Okay, so you can observe how the infringement will be there, just seeing this video, which is just for your understanding. Okay, that is about there are several cases of patent infringement. We can look into the uh, websites regarding the patents. You can see different cases. That is a Nokia sued the case Apple for violation of its patents regarding the several wireless technologies, and Apple filed a lawsuit against HTC for infringing on the Apple patents. So many cases of infringement will be there, and in this we and other important thing regarding this infringement and other things in the Indian patent system. There are punishments also, that is offences and penalties also, which we had not much discussed in this. The offences and penalties also will be changing from the amendments to amendments. There are different types of penalties, that is a fine will be there, and imprisonment will be there based on the type of thing. For patent infringement, for certain type of patent infringement, certain type of penalties will be there. and based on the type of offense there will be penalty offense and penalty will be there. So based on the type of offense the penalties will be changing based on the decision of the controller or the court, the decisions will be changing. But what are the different penalties which are mentioned in the website, we can see in the IP India website, and we can go through this. That is coming to the conclusion of the series of videos. Here in this we had learned what is a patent, how to file a patent, what are the patentability criteria, and how what is the procedure we have to follow in the in patenting, and what are the different means things which in the journey of the patent, that is patent opposition, patent infringement, compulsory licensing, revocation of lapsed patents. These are the different important things regarding the patent language which we have to, which we discussed from the in the past videos and in this video. Okay, so I feel that this modules had given you a brief idea regarding the Indian patent system, which you can learn. Basing on this idea, you can learn the sections, everything from the Indian Patent Act 1970. And thank you